Hello. Uh, in the previous slide, we saw the concept of capacity to contract, and we have understood it. Now we shall discuss what is free consent. Under section 14, free consent is defined as consent is said to be free when it is not caused by coercion, undue influence, fraud, misrepresentation, or mistake. Now, what does this all mean here? It means that when you're entering into a contract, are you doing it under pressure? Are you doing it because somebody is influencing you? Are you being tricked into entering into a contract? Obviously, this is not a free consent. You are not giving your assent or acceptance. Normally, if somebody is trying to, do it to you by force or any other way. So this is what we mean that a valid contract happens only when you have a free consent. Question, the first one, let's see. It is committing or threatening to commit any act of forbidden by the Indian Penal Code, or the unlawful detaining or threatening to detain any property to the prejudice of any person whatever, with the intention of causing any person to enter into an agreement. So in short, it means that when you are coercing a person, you are actually trying to force that person into enter a contract, enter into an agreement, which is not valid. For example, Ashok threatens to shoot Bridges if he does not let out the house to him. Bridges agrees to do so. This agreement has been brought out by coercion. He was forced into entering into this contract, into this agreement, because he was threatened to be shot. So that obviously this contract cannot be valid. In fact, it would be illegal. Undue influence. Section 16(1) says a contract is said to be induced by undue influence where the relations subsisting between the parties are such that one of the parties is in a position to dominate the will of the other and use that position to obtain an unfair advantage over the other. Now, in short, it means when you're forcing somebody through domination, right? When you're influencing somebody through domination and getting an advantage or getting the agreement, then it is undue influence. So when is a person deemed to be in a position to dominate the will of another? Where it is real or apparent authority, where there is real or apparent authority, it can happen. In a fiduciary relation where there is a head of the family or in a head of the organization where he or she pulls all the strings. Mental capacity temporarily or permanently affected by a reason of age, illness, or mental bodily distress. Here also dominance can take place if you are not physically fit, if you're mentally not well, if you're distressed. Here examples are relationships of father and son, guardian and ward, husband and wife, doctor and patient, trustee and beneficiary, solicitor and client, pardanishin women would all fall within the ambit of undue influence. Fraud. Section 17 says it means and includes any of the following acts committed by a party to a contract or with his connivance, right, or by his agent with intent to deceive, that is, trick somebody, any other party thereto, or his agent, or to induce him to enter into the contract by trickery, by deceit, right? This is fraud. Now what is, how do you create fraud? Like, look at these points. Number one, suggestion of a fact which is not true. Now you're trying to suggest a fact, you know that it is not true. This is fraud. Two, the active concealment or hiding of a fact by one having knowledge of the fact. You know the fact, but you are trying to hide it. Three, a promise made without any intention of performing it, non-performance and breaking the promise. Four, any other act fitted to deceive, any other act which is fitted to trick, fool, right? A fraud is a fraud also. Five, any other such act or omission as the law specifically declares to be fraudulent. So when is silent or silence fraudulent? Where the circumstances of the case are such that it is the duty of the persons keeping silent to speak, or where silence is in itself equivalent to the speech. So if you have a duty to say, and you don't say it, then it is definitely a fraud. So if you don't have a duty to say anything and you don't say it, no one can oblige you to say anything. This is not a fraud. For example, X says to Y, if you do not deny it, I shall assume that the horse is sound. Y says nothing. Here Y's silence is equivalent to speech, right? And here this because it is equivalent to a speech, because he had a duty to say yes or no, then it is, when he says silent, means it could be a fraud. Misrepresentation. Consent given under misrepresentation of facts is not consent at all. A statement made which in fact is not true under the belief that it is true is misrepresentation. For example, X says to Y that Z's horse is of a very good breed and can run 40 kilometers at a stretch. X believes it to be true and Y buys the horse from Z. It turns out that the horse can run only 4 kilometers. This is misrepresentation. Here X did not know that the horse could run only 4 kilometers. He believed as he was told from Z only. So X believed it and he made Y believe it, right? So obviously this is a misrepresentation. Mistake. An erroneous belief about something is called a mistake. You believe something which is totally not right, so it is, then mistake can happen. So when an agreement is entered into under a mistake, consent is not free. Mistake is of two kinds: mistake of fact and mistake of law. Let us see each of these. Mistake of fact, where both the parties to an agreement are under the mistake as to a matter of fact essential to the agreement is void. For example, X agrees to buy from Y a certain breed of buffalo. It turns out that the buffalo was dead at the time of the bargain. Though neither party was aware of the fact, the agreement is void. It is void because while the agreement was taking place, somewhere else in the remote area or in the farm or in the village, the buffalo concerned which was being sold was dead. So obviously there was no deal. It was void. Mistake of law. Ignorantia juris neminem exequat. That is, ignorance of the law is no excuse. The mistake of law is the legal principle that refers to one or more mistakes that are made by an individual in understanding how applicable law is applied to their past activities. See, you just can't say that I don't know the law, I don't know the rule, and think that you will not be penalized or warned. It is, a duty of every citizen to know the law. Ignorance is not an excuse. For example, Sunil at crossing did not stop his car at a red signal. Traffic police charged him for breaking the traffic rules. Here Sunil cannot plead to that he was not aware of the law. See, traffic is very basic and fundamental. Everyone should know the traffic rules. He cannot say he did not know the rules. So he will be charged. Generally, the mistake of law cannot be taken as defense and is not excusable, as it is assumed that other than minor lunatics and insane persons know the law of the country where she resides. So a normal person, a person of sound mind, cannot say that he doesn't know the law. Only these people, minor lunatics and insane persons, can be excused for not knowing the law. Thank you very much. We end here.